The topic that I'm going to discuss with you today is doesn't really lend itself to pictures. I prepared some materials, and what I want to talk to you about is the judges of the Third Reich. What I'm really talking about is how did we get here? How did we get to that Nuremberg trial? What changed in the legal culture of Germany to create a jurisprudence and judges who would sanction and approve the horrible crimes that you saw at Nuremberg? Because these were legally sanctioned crimes that were a result of a particular culture that were uniquely created. And honestly, as we all know, to look at this is to understand how you can make sure that this never happens anywhere else. And to recognize, and when I went through the material, I felt to recognize that we're always in danger if we're not vigilant to have the horrors that we see here repeat themselves intellectually throughout the world. I want to particularly thank, before I begin, my law clerk, Gordon Lyon, and also John Ewell, who was an intern in my office and helped me prepare these materials. I did give you an outline of my talk, and it was attached materials. I want to start this morning by talking about the Weimar Republic. And among your materials is a chart that outlines the court system of the Weimar Republic and the additions that were made to the court system by Nazi Germany after 1933. And interestingly, I want to begin with what's called the Eminger Doctrine. I think one of the beginnings of the fall. Within the Constitution of the Weimar Republic, as you all know, the Weimar Republic was after Germany lost the First World War, it became a constitutional democracy. The Constitution of Weimar was the legal document that guided the republic that was created. In 1924, Article 48 of the Weimar Constitution allowed, in cases of emergency, for the Constitution to be suspended. In 1924, part of the Constitution was suspended in Germany as a result of a series of violent uprisings that had taken place, and the jury system was abolished. Shortly after that, one of the most famous Nazi trials took place. It was the trial of Adolf Hitler in Munich for the Beer Hall Putsch, I believe is how it's said, which is just a coup or an attempted takeover. Now, after the abolition of the jury trial system, the case itself was tried by a trial judge named George Neihardt. Since the jury system had been abolished, Judge Neihardt, with two other judges, and I believe three lay judges, as they were called, were part of the panel that supervised the trial. Hitler was arrested. He was charged with treason after the uprising in 1924. He ended up doing 8 months. He was convicted. He ended up doing 8 months on a 5-year sentence. He had three great benefits that came out of this trial. First, he received an enormous amount of attention, became an international figure, and the leader of the right in his country. Secondly, he finished Mein Kampf along with Rudolf Hess, and who he allegedly dictated it to. Hess may have co-written it, that's unclear. And the final benefit, though, and I think the thing that has historical resonance, is that Hitler realized after the end of this trial that he could achieve his goal through legitimate means, that he did not need to use force to conquer Germany, that the law and the structure of the government, and through the law, he could take over the country. It's one of the great terrors of history that Hitler was an elected official. He didn't take over like Stalin did. He didn't take over through assassination. He took over through the use of the law. And that revelation, that lightning moment came to him at the end of the Putsch trial in 1924. Now, he had fellow conspirators, Hess, Goebbels, they were all there. The usual crew were there. One final point, though, on the Putsch trial is Neihardt was concerned at the end of the trial in how he would sentence him. Because the law at that time, it's kind of an ironic twist, is that Hitler was an Austrian. And if you were convicted of a crime, you were required to be deported. And so Hitler says he was an Austrian, should have been deported after, but Neihardt gave an interesting analysis. The reason he said that he couldn't, he wasn't going to deport him because he couldn't imagine a man with a more German mindset than Adolf Hitler, and so he refused to deport him. You know, in the context that we're living in right now, and this is kind of a startling revelation. But that change in outlook, the denial of the application of the law when the judge had a chance to deny it, history turns on these moments. It always does. Now, after the 24 trial, you'll see in my outline there's some minor things I want to talk about before we get to the Reichstag fire trial. The Nazis took over in 1933, and when they took over in 1933, they began to coordinate with the professions, the medical profession, the educations, the universities, and they also began to coordinate with the courts. The German judges were almost all civil servants. They belonged to a German federation of judges. Hitler took over in January of 1933 as chancellor. The German Federation of Judges, in the beginning of their coordination with Nazi ideology and the acceptance of the Nazi version of how the law should be promulgated, passed a declaration. Basically, the Federation of Judges expressing the will of the new government to put an end to the suffering of the German people. Quoting now, "May German law hold sway in the German community. German judges have been loyal to the nation and are aware of their responsibility. The declaration ends with the assurance that German judges place their full confidence in the new government." Shortly after that, in April, the law for the restoration of the professional civil service, which drove every member of the Jewish faith out of the legal profession and almost all the other professions, and also all the judges who were Jewish out of the judiciary, along with social democrats and otherwise politically unreliable. This happens after this, of course. The legal profession and the judges continue to declare, "We have placed everything in his hands," referring to Hitler, "with complete confidence." The Chancellor was clearly in agreement with our remarks, and he assured us that he would continue to maintain the independence of judges. We therefore rest assured that the regulations contained in the law on civil service will be dropped as soon as possible. It was wishful thinking. Now, continuing on, after they continued to coordinate themselves, I want to just highlight a few of the judges of the Reich. One of them is Edward Bumke, B-U-M-K-E. He was the highest judge of the Reich. He became the chairman of the Supreme Court. His interpretations of the race laws that were passed by Nuremberg, or in Nuremberg, is a decision that I attached in your materials. It was for the first, Bumke's important because for the first time legally, he establishes the principle of the inequality of races. Judaism wasn't a religion under Nazi ideology, it was a race. And this inequality of the races was the legal underpinning for the Holocaust. This inequality of the races, in his opinion, created the justification. Now you say, why does this matter? You know, why didn't they just do these things by force? Well, the law was their weapon. The Germans required the law. There's an interesting thing I'll talk about a little bit further on, where the Germans judges were given by Otto Fuehrer. He was the man who became the Minister of Justice in 1942. Fuehrer sent out a letter to all the judges, and they're all sent out confidentially, instructing them on how they were to deal with various parts of enforcing the law, and particularly at this point, blackout regulations and applying the death penalty. But the interesting thing about it, for our purposes right now, is they were all made confidential. Everything was kept secret. All the letters to the judges were kept confidential because the German government, the Nazi government at that time, was concerned that if the German people thought that judges were being told what to say, it would undermine their confidence in the legal community. So in order for the legal community to do what they wanted them to do, in other words, for the legal community to support the Nazi ideology, the appearance of independence was essential to provide that power and that push. Bumke. Anyway, Bumke's decision post the Nazi race laws, of course, dealt with what are referred to as sexual relations between couples. Sexual relations, I'm not going to go through the decision, it's lengthy, but did not require ultimately that there be any bodily contact between Germans who were Jewish and Germans who were not Jewish. It required the death penalty for any contact or sexual relations in any form. The law, as you'll see when you read the decision, it's in the attached materials, if you get a chance to look at it. The language that's used is couched in terms of not just German blood, but German honor. In preparing these materials, I have to say that some of the language in the decisions it's almost difficult to read, and to talk about publicly. But you can't be afraid of it. I think you have to confront it and recognize the reality of it. Otherwise, things like the Nuremberg trial really don't mean anything anymore. The only way history really lives and history protects us is if we are able to confront the evil that was in the past. Now, after the Nazis took over in 1933, they created a few new courts. One of them is the People's Court. That was a wholly new court. I want to talk to you about that separately. It was owned by a man named Roland Freisler. But also a special courts were also created. In effect, these dealt with, and you'll see it in your chart, the criminal jurisdiction over cases. Now the goal here, to quote the law that created it, was the elimination of formalism in criminal proceedings. Well, of course, you can imagine what that meant. That there was no cross-examination. You were not entitled to a lawyer. You were not entitled to know the charges ahead of you before the trial began. It was, in essence, there was evidence put on it, and then a decision was made by the judicial panel. Let me just give you some examples. A lot of the crimes that you see when you look at these cases have to do with crimes that are related around violations of blackout regulations during the war. It applies to both to Germans across the board. One is, just one example, is this guy named George Hoepke. He's a wounded vet, a wounded German soldier vet, along with a friend of his, Fritz Nuland. There's a fire. They go in to help people and to take property out. As they're taking the people and the property out of the fire, they're helping the firefighters. One of them puts a knockwurst in his pocket, and the other one puts 2 bars of soap. They both are given the death penalty. Now, this is not the worst. There's a long, long list. An interesting book, and a book I referred to on is a book by Ingo Müller. I think it's arguably one of the most important books about application of Hitler's justice in the courts of Nazi Germany. But he goes through long, long listings of hundreds and thousands of cases. To give you some idea, just the People's Court alone that was run by Freisler, in a 2-year period, gave the death penalty to 5,200 people. It's estimated that the special courts and the People's Courts, estimates run anywhere from a low number of 16,000 to a high number of 70,000 death penalties that were given for violations of what we would consider either violations in Buffalo City Court or at most to be misdemeanor. And this was common. It was applied across the board to everyone. Now, I want to take a step back and talk to what I think is the key event in the transformation of German law, and that's the Reichstag fire and the trial that subsequently evolved. As you know, Hitler was appointed chancellor in 1933, in January of 33. The fire itself, the Reichstag, was the government building. It was the House of Congress. It was like the parliament for Germany. In February of 33, the fire began. Now, the fire and the ensuing trial represent the decisive development, as I said, in the actual takeover of the government. First thing that happened is afterwards, Article 48 of the Weimar Constitution allows, in the event of public order and security are seriously disturbed or danger, the Reich president may take the measures necessary for the restoration, intervening if necessary, and eliminates all personal liberties, private property rights, secrecy of postal and telegraphic communications, freedom of expression, freedom of assembly, association, and inviolability of property. All those rights under the Weimar Constitution are immediately suspended. Hitler got Hindenburg to sign Article 48, suspending them. Afterwards, there's a trial that takes place. A young man named Martin van der Loo is accused of setting the Reichstag on fire. The trial, interestingly enough, is from the highest court in Germany, the Supreme Court. They find van der Loo guilty, but there are a number of other co-conspirators who the Nazis charged, and they tended to be social democrats and communists, and they were all found not guilty. They had nothing to do with it, and they were just simply thrown into the pile in an attempt to give them the death penalty. After the Supreme Court did not convict them, which was a startling decision to the Nazis, there were a series of laws that were passed in reaction. The first was taking the control and the jurisdiction of all issues of treason away from the Supreme Court, the highest court in the land, and given to the People's Court, this newly created creature in the Ministry of Justice. After that, the next thing that happened is a number of laws were passed to deal with it. First was a decree for the protection of the people in the state, which is also called the Reichstag Fire Decree, and that suspended the Constitution and all the rights we talked about pursuant to Article 48. The second thing they did is they passed what was called the Enabling Act. These are all the foundations of Nazi jurisprudence. The Enabling Act basically said that national laws can be enacted by a cabinet, did not require a legislation through an assembly or any vote of the assembly, and the cabinet will take the recommendations of the chancellor, and the law becomes the law the same day that the chancellor announces it. The third thing that happened after jurisdiction was taken away and all rights were suspended for the entire country was the passage, from a legal point of view, is interesting. It's called the Lex van der Loo, which referred to van der Loo, the law of van der Loo, because he was the one who got the death penalty. But what it did is it suspended the concept of ex post facto. Hitler became chancellor in January. Van der Loo committed the crime a month later. It was a crime of arson. Arson was not a crime for which one could get the death penalty in Nazi Germany, but arson was made a death penalty crime in the van der Loo law, and it was applied retroactively to when Hitler assumed office. And of course, Hitler was subsequently executed after that. I want to just turn a little bit from the Reichstag fire trial and the changes in the law that came out as a result of it to some basic concepts in Nazi jurisprudence. There are four that I outlined for you, and the first, the most important, are the passage of the Nuremberg laws, which in essence institutionalized anti-Semitism in Nazi Germany. Let me get this date here. In 1935, you've probably seen film of it. Leni Riefenstahl's film is very famous, of the Nuremberg rallies. In 1935, Hitler was there, and the Nuremberg rallies were taking place. And he kind of almost casually came up with the idea, there wasn't a written program ahead of time, in the midst of this rally, the very famous rally, to pass a series of laws that dealt with what he saw as the fundamental issues of the preservation of the German race. There were three laws that he had passed at Nuremberg at a party conference in the rally. The first is the flag law. The swastika became the party symbol. The second was called the law on citizenship, and to deprive those not of German blood of their rights as citizens. And then, of course, it went on to define what a German citizen was. In the third, and arguably the most heinous, would be the law for the protection of blood and honor. It's attached to your papers, and in essence, it forbids marriage between Jews and non-Jews. It's characterized as sexual relations, and you've seen previously how that's been defined. The second principle of Nazi jurisprudence, and Nuremberg would require a separate conference. We'd have to spend 3 hours on Nuremberg alone, just the ramifications of the law, the effect of it. But I just want you to have in the back of your mind that this was one of the foundational elements of Nazi jurisprudence that created the basis for them to carry out the crimes in the name of the law. And the judges implemented these laws. Anyway, the second point is what was called the Fuehrer Principle. And it's referred to in the materials, which basically means it's the Nazi leadership principle. In some ways, I think it's important for the Nuremberg trials because it's used as a defense in Nuremberg, along with the idea of positivism. I'm running out of time here, so I'm going to try and go through these quickly. Among the materials I want you to look at also is the concept of nulla poene sine lege, which means no penalty without law. That principle was turned upside down after the Lex van der Lubbe law. You can impose a crime without any punishment, and what is not allowed under German law became forbidden. Let me just talk a little bit about the People's Court. As I told you, it grew out of the Reichstag's trial. It was given jurisdiction over treason, high treason, and attacks on the president, destruction of military property, assassination, or attempted assassinations. The first Minister of Justice, Adolf, said its purpose is not to dispense impartial justice, but to annihilate the enemies of National Socialism. He was replaced and he became a minister he took over Bunke's place on the High Court, and Roland Friesler took over in 1942. I mentioned him briefly in the context of the death penalty before. Friesler was a member of the Nazi Party since 1924. Now, interestingly, and frightening also, is that Friesler was the judge who supervised the assassination trial of Adolf Hitler. As you probably know, it's called the July 20th plot. They made a movie about it, Tom Cruise was in it. There's been a number of discussions of it in popular literature about the July 20th plot, an attempt to assassinate Hitler near the end of the war. There were 7,000 people arrested. 4,900 of them were given the death penalty in connection with the plot. The trial itself of the main co-conspirators was filmed. And the purpose of the filming was to show the world how impartial German justice could be, because the beloved Fuhrer had been attempted to be assassinated. The film itself, if you see in your materials, it's still available. You can get it on the internet. Steven Spielberg, the Holocaust Memorial Museum, has a 2-part version of it, so the original film is available. It's a frightening thing to watch, but it gives you a real sense of the way these trials were conducted. Martin Bormann, as you know, who was the secretary to Hitler, watched the film and said, in essence, that, let me quote from him, the presiding judge totally lacks the kind of ice-cold authority and control. He made quite a bad impression. He seriously undermined the gravity of the proceedings. In other words, Martin Bormann thought that Roland Friesler was such an incompetent, terrifying, one-sided, biased judge that it would be a propaganda defeat for Nazi Germany to show a film of this trial as an example of the quality of German jurisprudence. If you watch it, you'll see Martin Bormann was right about that. Now, Friesler's kind of important. There's an essay by Robert Reichland in a book called The Law in Nazi Germany. I'd recommend it to you. If I were going to recommend 2 books to you on this topic, it would be Ingo Müller, Hitler's Justice, and then The Law in Nazi Germany, which is in the bibliography of the materials I gave you. I think those essays set out all the dimensions of Nazi jurisprudence. But anyway, Friesler, in essence, helped create the jurisprudence that the Germans were relying upon. He was actually kind of an accomplished German. There's a jurist. There's a historian. His name here. I can't find it. Anyway, he said that the Germans, even when they were hiring someone to perform mass murder, demanded high bar exam marks, and Friesler falls in that category. Anyway, there's not much humor in this material. Roman law, Friesler said, Roman law, which is the law for the rest of the world, asserted a materialistic worldview, and it should be replaced by German common law. He also said that the supremacy of law as a principle in organizing society had to be abolished. Hitler relied on these marks in a speech to the Reichstag in 1933, outlined this principle, and it was adopted. Now, there's one final point I want to refer you to, and we don't run out of time here, but I want to talk a little bit about the positivist defense. In the trials in Nuremberg afterwards, and throughout the jurisprudence of the Nazis, the principle is that I was only following the law. This is the law that my government provided to me, and I had no choice but to obey it. I have been trained in this. This is part of the German tradition. We were required to do this, and that's on one hand. On the other hand, the defense also is the Fuehrer, whatever he says is the law. It's not passed by anyone, and I took an oath to the Fuehrer, and I was required to also obey him. Those two defenses are at the core of the confrontation, the ethical and moral confrontation that constitutes the Nuremberg trials. And interestingly enough, every law student knows when we go to law school now, we read Neihardt. We talk about the separation of law and morals. And Neihardt is in a debate that's resonated throughout legal history with Lon Fuller. And one of the examples they use in discussing the moral quotient of the law and how the law and morals, and if the law and morals can be separated, is a Bamberg County Court trial that measures the application of the law to a woman who turned in their husband to Nazi Germany for listening to the Nazi authorities, for listening to a foreign broadcast on a radio. She was having an affair with a man. She wanted to get rid of her husband. She turned him in to listen. He was given the death penalty. There's a lawsuit that's brought afterwards. He's dead now. And the question is to the Bamberg court is, can this law, which is clearly an immoral law, be used as a defense to her? She said, I was just following the law. Bamberg County Court in Germany, one of the highest state courts in Germany at that point, in the late 40s, says no, they can't. Neihardt argues that was judicial activism and that that's the law gone wild. Fuller argues the opposite point of view. I think that ultimately we're left with a moral nightmare if we accept that as our version of the law. I think that what my review in Nazi jurisprudence says to me is that the abandonment of the law does not require the abandonment of all moral principles. We're going to discuss it later with Professor Miles in great detail, and I think it'll be an interesting topic to discuss among ourselves, because it's really the point where here, this is why history lives. This is what it means. This is what it's all about. One of my colleagues on the Court of Appeals, and everybody from Buffalo probably knows him, there's only been 4 judges directly from Buffalo, I think. There was Judge Matthew Jason. And I don't know if you remember Judge Jason, but he had been first elected to the Court of Appeals, and then he had been on the Court of Appeals appointed also. He retired in 1985. But Judge Jason began his career as one of his jobs he worked in Heidelberg and had been a prosecutor, but then he became an assistant prosecutor to Robert Jackson. And after he became assistant prosecutor Robert Jackson, he also became a military judge in Heidelberg post that. As a matter of fact, his son says that Jackson told him that he wanted to be elected to the state Supreme Court. He said, "You're a Democrat, Jason. You're never going to be elected to Democrat state Supreme Court in Western New York. That'll never happen. The world's changed." Anyway, when he retired, he made a few remarks at his retirement, and he talked about his experience, and I just want to leave you with it, and leave you with a sense of the dignity of the man and the principles that he espoused. My tenure in Germany exposed me to a tragedy of universal implication, the horror of the Holocaust, specifically. Never in the history of mankind were so many innocent women and children singled out, men, women, and children singled out for persecution. This spectacle of human evil unleashed upon the world was officially sanctioned by the Nazi government. The courts of that country enforced this reign of terror. I began my career there as a judge, and it was a challenge to do justice to the offenders of American law in that foreign land, whose conception of justice was the ultimate result of a long evolution of doctrines, raising inhumanity to the level of a principle. The American view of justice was not immediately understood as the Nazi leaders during their reign, and posited their theory of justice according to defined and generally accepted authoritative precepts, but according to their individual conception of justice without respect for any human values. The rule of law as we know it was replaced by a new order of the edict to carry out their master plan of conquest and oppression. I was shocked to learn that the judicial branch of the government acquiesced in this spectacle of human evil. Recognizing the moral consequences of judicial action as well as inaction and silence, I resolved then and there to do my part to ensure that our judiciary remains strong and dedicated to the government in accordance with the rule of law and not man. It is fidelity to the rule of law which has served for 28 years as the foundation of my judicial faith. I want to leave you with the idea that, and a thing to remember, is what is called law by Nazi Germany is not law at all. It's not an expression of the will of the people. It doesn't have the force of sanction, and it doesn't have the force of morals. And to characterize it as such is intellectual dishonesty of the first order. And it's the law is what protects us. The law is not what destroys us. And we've got to never lose that principle. And I think that Jason said it best, and kind of lucky to be in the same place as he was. Thank you all.